Okay, thank you everyone for coming today to what should be a very, very interesting panel. My name is Stephen Klein. I work for a company called Cammeby, dealing mostly with compliance. Compliance is a very important topic in New York City real estate these days. We have a very illustrious group of panelists here. We're going to go through and introduce ourselves, starting with Josh here in just 1 minute. I just wanted to add that we're going to do this very quickly because we just finished lunch and it's almost time for supper. Well, that's kind of what we do. We try to squish in some productivity in between meals. So we're going to do that today again. For those still talking in the back, the gentlemen from HPD that are writing down your names and your companies, and they're going to be sending out violations later today. Okay, so Josh, whenever you're ready.
All right, thank you. Good afternoon, everyone. My name is Josh Cucchiara. I am the Associate Commissioner of Code Enforcement at HPD. Our responsibilities include enforcement of the New York City Housing Maintenance Code and aspects of the New York State Multiple Dwelling Law. It's good to be here today. Thank you.
Good afternoon. My name is Barrett Einlager. I'm the Assistant Commissioner for Asset Management. Asset Management for HPD works with owners, lenders, community partners, managing agents, and other government entities to ensure compliance, maintain affordability, and ensure that the projects maintain their suitability as affordable housing during their full life cycle.
My name's Seth Denenberg. I'm a partner at Hertz, Cherson, Rosenthal. I've been doing landlord-tenant real estate work, representing property owners, both in the housing court, in front of DHCR, cases against HPD, closings for over 40 years. I can afford insight into how to try and make the broken housing court system work as well as possible, and alternatives as well as ways to defend cases and prosecute cases, and also defend administrative actions in front of the HCR.
I'm Jay Martin. I'm the Executive Director of the Community Housing Improvement Program. We represent 4,000 rent-stabilized majority property owners in New York City, 400,000 units, soon to represent 800,000 units of rent-stabilized housing.
Okay, so we're going to start our first question with Mr. Martin. For quite some time now, we're hearing a lot of talk about distress in older rent-stabilized buildings in New York City. How did we get here, and what are we going to do about it?
As you might imagine, I'm asked this question all the time, every day. And I don't have to tell many people in this room how it happened, but I'll do a brief recap. The 2019 rent laws drastically changed the operating and business environment for majority rent-stabilized buildings throughout the city. So any building built before 1974 had their business model essentially turned upside down.
Right.
That law, which we are still working on lawsuits to challenge and change, and working every day in Albany and the City Council to try and change and peel back, is step one. Step two was within 12 months of that law, a pandemic that shut down the economy of New York City, which contributed to massive rent arrears that we're still dealing with. And I'm sure some of my fellow panelists are going to talk about the huge rent debt that many of our property owners and many people in this room are probably dealing with. And then you had interest rates go up at the same time. So those three things kind of contributed to what we're seeing now, which is a devaluation on many properties as high as 70%. And it's going to take a combination of fixing all three of those things, interest rates going back down, clearing out the housing court backlog and fixing the housing court process in the long term, and drastically changing the rent stabilization laws for owners to get the value in which they deserve and frankly are entitled to in the buildings that they invested in initially in these properties.
So there's been some talk over the past week or so about rates going down a little bit. From what I'm hearing you say, that's not enough.
Yeah, I mean, that will help folks. You know, the question I'm often asked by the real deal and people who are like, well, where are all these foreclosures? I thought, rent stabilized was struggling. And there's a fundamental misunderstanding of the difference between office and warehouse rentals, and the vacancy rate in rent stabilized majority multifamily pre-74 buildings that we deal with, and many of you know, is very small. And so the lack of large vacancies allows many owners to kind of just float at the surface of insolvency. And they're kind of biding their time before they get into this period when we'll have to refinance, which is where the lower interest rates will help on refinancing, but the operating costs are so high comparative to what they're able to collect on the rent rolls that they can reduce their operating costs as much as they want. The inability to keep increasing the rents to keep up with those costs is the primary concern.
Right. Okay, Seth, over to you. Housing court, it's a mess. Since COVID, there's been a tremendous backlog, and we're still dealing with it. What are some tips or tricks to navigate housing court in this current environment?
Well, first, let me just say this. Initially, we were able to blame the backlog on coming out of COVID. That's really not true anymore. The backlog is basically self-inflicted and created by the city government, which created the system of universal access. It's an interesting thing. Politicians always manage to pass laws that create more litigation. We passed laws that open the doors to Supreme Court cases. These lawsuits by people who suddenly remembered 70 years later of childhood trauma, without increasing the ability of the courts to deal with those cases. So in the housing court, we created something called universal access, which gives every single tenant a lawyer. Now here's the irony of that little scenario. I handle a caseload. The attorneys in my firm, we handle caseload of say 100 cases. By contract, these people handle 40. 1/3 the cases we handle. Now, what do lawyers do? Lawyers litigate. We create work for ourselves. So this army of lawyers who have very little to do because they don't have enough cases per man, they create motion after motion after motion. And what the courts didn't do, and the politicians, not the courts, but the politicians didn't take into account, is that if you don't increase the number of judges to handle that volume of motions and of case law and of work and of trials and of everything else, you back up the entire system. So by hiring an army of lawyers, giving them small caseloads, they make motions and motions and motions. It could have all been alleviated. Instead of hiring lawyers at 120 a pop, you hire social workers at 45 a pop, and what social workers would do is help your tenants get the rents paid. You keep down your legal fees to me, which is really should be the goal. You get your rents paid faster. The backlog in the courts gets relieved because the cases move faster. So what you end up with is a situation now where the courts cannot give us court dates until 4 months after you file a case. Now, part of the solution to it would be hiring more housing court judges, first of all, doing away with universal access and getting social workers to get the rents paid for these people, and putting more pressure on the judges that are there to decide cases in an expeditious manner, and frankly, to use the laws of sanction and penalty and legal fees against these legal services people who act with absolute, carte blanche to make frivolous, stupid motions. How many times I go into court and I hear from them, I know it's a stupid motion, but it'll delay the case. It'll get me 3 months, and then and maybe then I can get the rents. And all that's done, by the way, in order to avoid judgments against their clients who have credit ratings of about 200 anyway. So what are we protecting them from to begin with? So you have a broken system. that's only been made worse by universal access, by the delays, and if the judges would just punish the attorneys for the delay, we could move it faster. From our perspective, we push as hard as we can. I don't agree to settle cases per stip. I insist upon judgments. You settle it per stip, your lawyer settles it per stip. That's only pushing the case down the road. He comes back to you and says, look, I got a stip, but what did he get you? He got it settled per stip, no judgment, no warrant, no nothing. So the legal aid lawyer, legal services lawyer got himself more delay. Insist that your lawyer brings back judgments. Don't just settle cases. Because what's that going to do? With the delays, you make your motion to restore when they don't pay the money. That motion gets pushed off 3-4 months into the future. You've accomplished nothing. You got to push as hard as you can. And that's just push. Keep pushing. And don't settle for anything less than what you're legally entitled to.
Okay. Very interesting. Thank you for that. Okay, so we're going to move on now over to our HPD folks. I spent some time with these gentlemen. They're nice people. They're on our side, I promise. Barrett, you're with HPD Asset Management.
Yes.
Can you tell us a little bit about what it is that you guys do? Maybe not everyone here is familiar. And how you can help us. We have quite a few people in the crowd who have buildings that frankly are struggling. And they're looking for alternative sources of resources to be able to help them get to where they need to be.
Well, asset management is tasked with maintaining the quality and affordability of New York City housing for low and moderate income New York City residents. And part of that is also to maintain for the full lifetime and oversee the properties. And there are a number of programs that HPD has that can assist, from the lead abatement. There are federal grants and loans. There's also the environmental that sort of fall into the green, where you can actually cut operating expenses and save on water, on your utility expenses. There are multiple rehab programs. There's also participating loan programs. And then housing preservation in terms of tax reductions. There's Article 11, and the state has recently authorized J51, and we're optimistic that the City Council will enact that shortly. And that's an as-of-right tax program for the rehabilitation and continuation of multifamily dwelling units. So there are a lot of services we can provide, and part of that is working with your asset managers. We're here to help you, and we ask for information, but that helps us understand what's going on in your property and your need. We're in the process of implementing a method not just to look at your risk ratings, which are outside evaluations of outstanding arrears to outstanding violation counts to determine risk ratings, to looking at your financials that you submit. And from that, we can do a trend analysis, which is year over year, to look to see what's going on and to give the owner some indications also. For example, if your accounts payable is trending up and your M&O is increasing, but it's lagging in terms of your collections. What that's often an indication of, especially in some of the co-op world, is the fact that passing through increases are not always happy events to your tenants. But it's necessary because you really need to maintain the properties as a going concern. And we're here to help. We're here to provide guidance and reference and to help where we can.
Okay, is there a resource, whether online or somewhere else, that building owners can go to learn more about these programs?
Absolutely. You can go to hpd.gov, which is the HPD online source. You can register by looking at hpd.pro. You can also look for HCR. You can HCR registration. You can look there under Google. Both of those have a wealth of information. HPD Online is a really good resource of information, of programs available, resources, who you can get in touch with, and it should be a tool that your teams use routinely.
Okay, great. Josh, over to you. I know it's not exactly what you deal with on a daily basis, but I wanted to ask you about the AEP program, HPD's AEP program. It's something that some people are dealing with. It's something that we're hearing a lot about. What is it? How do we avoid it? How do we get out of it if we end up with the AEP building?
Okay, thank you. So AEP stands for the Alternative Enforcement Program. It is considered one of our enhanced enforcement programs, and essentially it's designed to address conditions in some of the city's worst buildings. And so I think the number one thing I would preach is prevention. Stay out of AEP. And I think property owners can do that by keeping violation counts in check, avoiding open emergency repair charges. So when we do issue immediately hazardous C violations that trigger emergency repairs, getting your contractors and in-house staff out to repair things as quickly as possible, and then certifying corrections of violations once that has been completed. In addition, when a building has been selected for AEP, there's a 4-month window that property owners can reduce the open violation count. So that would be something else I would strongly recommend. If a building does find itself in AEP, that there's a rigorous effort made towards bringing the violation total down. And each of the AEP buildings is assigned a coordinator. I think it makes a lot of sense that, again, if you own a building that's in AEP, to communicate with the coordinator, to understand what's going on, what it is the agency's looking at and looking for. And I would also suggest seeking legal counsel. I think it's always good to hear and to speak with an attorney about the legalities associated.
Got it. Okay, I see Seth laughing. I'm assuming you have something to add to the topic?
Well, you don't want to reach the point where you're in AEP and you have to get to me. The real trick is to avoid getting into AEP. And my colleagues over here from HPD are not going to appreciate my saying this. First, certify your violations as corrected. You don't know how many times I hear, especially from small property owners, I corrected it, I fixed that, but you don't certify it. And if you don't certify it, as far as HPD is concerned, it still exists. You got to certify your violations as corrected. That does not mean lie, because if you get caught lying, that's even worse than not certifying. But every time you do something, certify it. You gotta certify it. And if you took too long to do it, spend the $300 and get a dismissal request via inspection done before there's a comprehensive building-wide case brought against you, and you can't do that anymore. Because once they do that, then you're going to have to hire me to get it done. And you don't want to waste your money on me when you can take care of it yourself. I should be the last resort. Don't think of me. That's number one. Number two, and they're not going to like this. Your staff needs to learn that when an ERP crew shows up at your building, the building goes on lockdown. Make them sue you for access and use that time in the interim to do the repair yourself. You don't want a city crew walking around your building doing work and then hitting you for the bill, okay? Your staff needs to be taught how to identify a city work crew. That the work crew shows up, their first phone call to the superman should not be to his wife or his girlfriend, but should be to you. Did you send workers over? No, I did. Shut the building down. All right? I mean, and then you have to react and do the work. Don't ignore it. They're going to sue you to get in there. In the interim, it gives you the chance to do what you should have done before it got to that point, but it's better late than never. And I am never, because you never want to have to hire me.
So I just want to say, whoever thought to invite Seth to the panel, it was a very good idea. Sticking with you for a second, Josh.
Can I just say?
Yeah, of course. You're allowed to rebuttal.
No, not a rebuttal. It's just interesting to hear the perspective. So I'm relatively new to this position, but prior to serving in this capacity, I oversaw the emergency repair and demolition programs for HPD for several years. So it's interesting to hear that that's the guidance being provided. We've sort of...
It's not necessarily kosher to do what I suggested,
but it happens.
It may have happened. Sticking with you for a second, Josh, one of my favorite topics, probably most people in this room, let's talk about lead for a minute. What's going on? What's with all the laws, Local 31, we have to take an X-ray in every apartment. We have situations now where post-1960 buildings were being given presumed lead violations. Don't you guys have a list of which buildings were built when, and is there any way to more effectively get this done without putting the entire burden on the landlord?
So the city has extremely aggressive lead laws. That's sort of needless to say. Quite honestly, we are also grappling with them, and over the next couple of years, there will be significant changes made to various requirements. Some positive, right? So in terms of like record production, a way out for property owners, a way to have violations closed, but also just an additional set of rigorous requirements. I think it is the law now, and so it is my job and the job of my team to enforce the law. And so the best guidance I can give you is familiarize yourself with the requirements and do your best to stay on top of them. I know they're significant, and HPD does try to provide a lot of guidance to property owners. So our website contains a ton of detailed information for addressing the new requirements. There are YouTube videos that are accessible through the website, produced by HPD with that same sort of goal in mind. So my suggestion is, for the time being, really avail yourselves of those pieces of information and do your best to stay on top of the requirements. And if you have political influence, feel free to use it. That's
okay. Good answer. Jay, question for you. Since 2019, the political atmosphere in New York City has not been very landlord-friendly. Do you see that? Yeah, that's an understatement. Do you see that changing anytime soon? Do you see it getting better?
No, I don't see it. I don't see it getting better anytime soon. I see it moderating a little bit. It's going to require a lot of work. I will say, and we actually talked about this before the panel, the mayor has worked to make agencies a little bit more, over the last 2 years, a little bit more realistic to work with in some capacities. We've seen it with HPD from some of our membership. At the same time, you have a city council who is very interested in passing punitive laws. Just last week, there was a proposal put in for mandating air conditioning. And then it's not just mandating air conditioning, it's mandating cooling levels, which is, it's complicated to hear how we would accomplish that if we're doing individual cooling units and in apartment buildings, that the owner would have to be somehow in control of each individual unit. And then on top of that, there's humidity requirements in the bill that the owner would be required to do. So that is just indicative of the level of thinking. Bills are proposed without any reality and any conversations with property owners. So I think step one is to accomplish first conversations with these lawmakers that will not necessarily get them to change their perspective, but at the very least, before they're putting in these bills, they're having conversations with us to pause before they're frankly making these agencies enforce laws that are very difficult to enforce and for owners to comply with, to stop them from putting in the bills first, and then get to the point where we're stopping them from putting the bills in altogether. It's going to require lawsuits. It's going to require winning lawsuits at certain levels, state and federal. It's going to require unelecting certain people at certain levels. And it's going to take a lot of time and money to do this, because the majority of the electorate is of a very specific ideology. And until there are repercussions for those elected officials to keep doing the same thing over and over again, they're going to keep doing it. And if they can keep getting elected doing it, they're going to do it. So we have to build in those repercussions.
Got it. So for now, no light at the end of the tunnel.
I have to be as realistic as I can be,
Okay,
but
go ahead.
we're gonna get there.
Okay. One more question, then we're going to open up to Q&A for our panelists. Seth, Shepard-Neely, the decision from 2022 that basically established that if there's no active lease, well, why don't you tell us about it and how it's affecting the court system now?
Shepard-Neely is a very difficult decision. It basically has said that if you don't have a lease in effect with the tenant at the time you start your non-payment case, your case gets dismissed. Now, it's interesting that there is a couple of judges. Shepard-Neely spoke, used to be everybody thought, the best way to put it. Everybody used to always think that if you were a rent-stabilized tenant, because rent-stabilized tenancies never end, even if you don't have a lease, you keep your protection, you remain rent-stabilized. I didn't need to have a lease because, after all, he's got protection. The only person who benefits from a lease is me, who gets a rent increase. So tenants play the cat and mouse game of trying not to sign their leases, because the longer they avoid signing the lease, the longer they defer the increase. So a lot of landlords sat back and said, you know what, it's not worth chasing them. I'll live with it. I won't take the $10 or $15 increase. Now, I always try to tell my clients that's really foolish thinking, because you got to think of owning buildings in the long term. Not tomorrow, but the next generation. You're going to pass them on to your children, and you've got to get those rents up. Even if it only goes up $10 a year, you will get it up. Eventually, you'll get it up high enough. But yeah, so what happened is, because a lot of landlords stopped pursuing, and the judges also took the attitude of, well, you don't need a lease because it's rent stabilized. And the appellate court said that for rent-stabilized tenants, if you don't have a lease, you don't have the right to bring a case against them in court. Interestingly, a couple of judges have recently issued decisions now saying, okay, Shepard-Neely only applies to rent-stabilized apartments. It doesn't apply to free market apartments. Now, before Shepard-Neely, almost every judge said that the requirement of a lease was applied to free market apartments because it wasn't a regulatorily controlled tenancy. You needed a lease to set the rent, to set the terms. So the difficult part of Shepard-Neely is, okay, now I can't sue anybody, they don't pay me rent, I got to get a lease signed, and then you end up with the conundrum that, and you go back to something I advocate to my clients all along, don't ignore a renewal lease, get them to sign it. Now, if you don't get them to sign it under Shepard-Neely, you can't even sue them, they could stop paying the rent, and then you really got a major issue on your hands. So the net effect of Shepard-Neely is doing what I had advocated to clients to do, but now you have to do it because of the case. You have to get all of your rent stabilized. And how do you go about doing that? I knew that was coming. I could see it on your face. You gotta follow the code. Send them the renewal lease 90 to 150 days before it's coming up at the RGBO. Everybody knows what RGBO means. RGBO increases. Now you're going to sit there and say, but the time has passed. What do I do now? Reset the time period. Send it out. And by the way, certificate, not certified, certificate of mailing. You got some very liberal judges who will turn to you, especially if you're in Brooklyn and you got Judge Sule Grant, who still thinks that she's a legal aid lawyer. She's going to turn to you, and her first question is going to be, where's your proof of mailing, counselor? You got to have. Mail it. I know. It sounds horrible. but you have to do it. You're going to spend $1,500, $2,000 on me to get a tenant to sign a renewal lease. It's going to net you $15 a month. But you got no choice. Now you have to do it.
Okay, thank you very much. Let's open up the floor to some questions. Mr. Katz, is there a microphone that we could use anywhere?
So we have on occasion where HPD will send an emergency repair order prior to the certification period expiring. So we have a few weeks that we're supposed to be able to repair the violation, and yet HPD can be sending an emergency repair crew before the certification date. So how exactly does that work? And the second question is, you know, you'll have certain violations, say a clogged sink, where you can unclog it, and tenants washing their dog, you know, in the bath every second day, and by the time you come down for a dismissal request, it's clogged again, and instead you get a full certification. So how are we supposed to deal with that situation?
So with regard to emergency repairs, our general operating procedure is we will not even attempt to visit an apartment with HPD personnel to scope for a repair until after the violation certification period has expired. That's the general operating procedure. That being said, there are certain instances where we come across they're all immediately hazardous by definition, but really immediately hazardous violating conditions. And in those cases, we may move in more quickly to attempt to make a repair because we're looking to protect the life safety of tenants in the building. And so a good example of a situation like that is a heat violation during, obviously, the heat season, right? Property owners are notified, will utilize registration information to notify them first of the complaint and then of the violation. But if repairs are not made quickly, the emergency repair program is aggressively moving forward and attempting to restore heat. All right? In terms of the other issue you raised, I'm sure what you just described happens, and it's frustrating. We are limited from an enforcement standpoint, from an inspection enforcement standpoint, to report the conditions we observe in the field, right? And so if we revisit an apartment and find a drain line clogged, we will find that violation falsely certified based on our observation at that time. I know it's not ideal, but essentially, I mean, I think that's sort of the property management game, right? Things are fixed and they break again.
Right, so like if you submit a picture and you show, hey, it was fixed, and this is a new violation, there should be some sort of a process to address that. It's something that can be implemented. It doesn't really need new law. It just needs a method to you know, where property owners can submit that proof, and you can treat it as something else and not a full certification.
Well, I'd say, you know, in general, if there is a specific issue that is unusual, we're not adverse to talking with property owners, listening to the issues, and then trying to collaboratively solve problems. All right, and what I would suggest in cases like that is that you familiarize yourself with personnel at the borough office where the building is, and try to work with that group on specific issues. And communication is always a very good thing. Yep.
May I ask a question? The New York City Housing Code or Housing Maintenance Code does have responsibilities, tenant responsibilities. How is it that HPD can come issue a violation for something that should be the tenant's responsibilities, such as keeping clean, and I'm talking about cleaning your kitchen, etc. We have something called Local Law 55, which obligates the landlords to go clean the kitchen if they so-called find evidence of roaches and whatever, which are due to the tenant's actions, because if you look on your computer, you'll see that the HPD inspector was there the month before, or the week before, or 6 months before, and that condition was not there. So that means it was not the landlord's doing, it was the tenant's doing. Or you can a disabled smoke detector would be the same category. It was there, you know it was there, the tenant removed it. How does that become a landlord violation?
So, as I mentioned, right, our inspectors are trained and required to report conditions that they observe during inspections. We're also mandated to respond to 311 complaints just in general. And so at the time of inspection, if they observe a violating condition, the violation will be issued. I understand that at times a tenant can be responsible for that condition, and there can be egregious cases where tenants are responsible for vandalism, etc. My suggestion would be to find an attorney like Mr. Denenberg and to explore your options as a property owner with respect to that tenant.
So HPD is not, dealing with the property owner the same way. They're treating them as hotel owners, where the tenant is expected to just come and go to sleep, come back the evening and find everything done for them. That's what you're giving them. We are not that. That's not what we are. There has to be some kind of definition in HPD that if this is a tenant damage or tenant negligence or whatever it is, the landlord should not be summoned.
So our standard is adherence to the housing maintenance code. I understand the frustration that you voice. It is not uncommon for different inspectors to visit the same apartment based on conditions, and they're not privy to the backstory of why those conditions occurred. So as I said, they will cite the violations that they observe while they're there.
Any more questions? Yes.
Is there any,
Hey.
will there be any punitive stuff for the local law 31 in the end? Basically, the deadline is August 9, right?
Basically, after August 2025, if local law 31 is not complete, are there going to be any fines levied on the property, on the owner?
If that information, so I think the property owners would be required to provide that documentation through an RPO, if I'm not mistaken. And if so, right, I mean, I would suggest if there is a bit of extra time needed, we will take that into account.
So the only way that HPD is going to gather the information that we're now putting together for local law 31 is through record production orders?
I believe that's the case, but I'm honestly not entirely sure about how we will get at that from an enforcement standpoint. That seems logical to me. I can confirm that and get back to you.
Because I know it is a newer addition to the record production order, Section 5, that is asking for that information. Okay, that's good to know.
What do you suggest landlords do when the tenant doesn't provide access to do corrections?
So I understand that tenants are required to provide access. Again, I would, and I hate to sound bureaucratic if I do, that's not my intention here, but I think that in those cases, you would want to speak with an attorney and require access.
Doesn't that take a year?
It takes some time, I believe. That was to the point that Mr. Denenberg made earlier.
We regularly bring that
hi.
up. Go ahead.
My question is that if ERP is sent to the unit as soon as the certification period is over, how is it possible that the time to actually get the tenant into court would be a lot longer than that? It's putting the owners in a position that they actually are falling on a double-ended sword.
Yeah, I hear you. So when I oversaw ERP, and I did work with a number of property owners, I think the path that I would try to take and would sort of preach to folks is let us know that you're unable to. Believe me when I say ERP has enough real work. They're not interested in the fluff. And so if you communicate with folks in the emergency repair program about conditions, they may in certain instances try to help provide access with a tenant, right? And sometimes that's been a successful path for correcting a condition.
So there is an outlet for a tenant who doesn't allow access. You could reach out to the ERP unit to get access for you to hire your own contractor.
Say that again, I'm sorry.
Is there, the ERP unit could assist the landlord with access to the unit to bring their own contractor in, not using the ERP contractor. The owner would be able to hire their own contractor and ERP would help them get access?
We've tried that on a number of occasions with varying results. But if generally within the ERP, if we are on hand and note that a tenant is denying access to a property owner and the property owner in good faith is attempting to make a repair, we would not move forward with those repairs in general.
Well,
If anyone has any questions for any of the other panelists as well, they're still here.
If there's inspector from HPD that doesn't stop asking my tenant access to give them violation, to give me violation, is there any way I could report this inspector and have legally go against him? Because I had a case in AP and the tenant was calling me and saying HPD harassing us to give them access to give you more and more violation. So is there any way we could, as a landlord, do something about that?
So, I mean, I would suggest a couple of things. If you believe there's some kind of malfeasance or criminality, I would reach out to the Department of Investigation. Separately, I believe if you do have a building in AEP, you should have been assigned a coordinator. You may also want to communicate with that coordinator, unless it's the coordinator who you're having an issue with, and talk through the issue and see if they can help run interference.
I have a question. I'm dealing a lot with HPD. A policy issue. If you would push that if somebody got ERP, emergency repairs came and resolved, let's say, 10 violations, would the HPD, in your opinion, consider to mark this as certified violation?
Generally, when the ERP, through one of their contractor, performs work, those violations will be closed out.
Usually it's not so.
They should be. There's a lag. I'll say that. There's a lag, but the violation should be closed out.
How do a landlord deal if HPD came down and did, let's say, 25 lead-based violations through ERP? The violation is removed, but the document is not there. He has no chance of communicating with the third party for the paperwork. And it stays there forever since the paperwork is not submitted.
So you're saying that you completed the repair work?
No, HPD did through a third party to ERP.
So the contractors who perform lead-based paint remediation for HPD are all
the
properly
same is
certified?
with the exterminator, with mold, all third party that needs documentation. There is no communication between the owner and the third party to remove the violation since it's going in defect status.
So I don't believe that emergency repairs, lead violations completed by ERP go into defect status. I can confirm and get back to my colleague here and let you know, but I don't think that's accurate.
Let's say post that the remediation inspection comes. It's already, let's say, 6 months after. But he has no proof and no documentation of the lead base has been done by a proper licensee.
No, I understand what you're saying. So the system that is shared by the code enforcement team and the emergency repair team should have sufficient communication and bonds between the two so that the housing inspector is aware that ERP completed that repair.
And the third party should be, any third party that needs to provide documents, it's going defect, it should be need to have known to submit the documentation.
So the way it works with an HPD emergency repair for lead is HPD personnel actually takes the dust wipe, right? So we're doing that ourselves and having the analysis completed before we close it out. You know, an issue that does come up quite a bit, though, frankly, is that we're not able to get access after we've completed work to take the dust. So that might be what you're referring to. Just thinking back to my ERP days. That is a pretty common occurrence, and to the point that was made a little while ago, that's generally because the tenants involved are not being cooperative.
So at least HPD shares something with landlords.
Yes, I guess so.
I have a question for you. Since people don't have any left resources in buildings, they're looking for all alternative resources to get. So basically, we're going back to the old days. is there a way that anybody who has a building that it's old, needs a new boiler, new roof, new windows, extreme amount of capital improvement, to call up HPD, and HPD will send them someone to consult and see what can be done from HPD, grants, loans, federal grants, state grants, whatever?
There is, in the Housing Preservation Unit, Year 15 programs where they'll need to get in touch with HPD and put an application in, and then it will be
Get in
responded
touch
to.
means what?
You can go to the website, and there's a wealth of information there, and look at all the different programs, and you can download an application and submit it, and then they'll respond to your need.
Hi, a question to Seth. If I have a rent stabilized tenant and on the DHCR you have one name, but he's subleasing it to a different tenant, or he has other tenant there, he himself doesn't live there, can this tenant take over if they are there more than 30 days? Can I evict them, or because they are there more than 30 days, they could take advantage and say they are the new tenant now?
Your tenant of record is still in the apartment. As long as your tenant of record is in the apartment, it's not sublet. The person that he takes in with him is a roommate. The case law has watered it down to the point where you can take in as many roommates as you want. Even worse, you can make money off of taking in these roommates. At one time it was you could take in only one roommate, but that roommate couldn't pay more than 50% of the rent. Now you can take in plenty and you can cover your entire rent and even make a profit. Okay. You're asking a second question though. If the tenant of record moves out, he's disappeared now. Then you get into the situation of succession. Does the person who's been living there have the right of succession? Do they have the familial relationship to get succession? Generally speaking, the roommate situation you're talking about, they're not going to be a brother, sister, husband, wife, mother, father, something like that. So there'll be no succession rights like that. But you might get into the case that I just recently finished a trial on and won, where the roommate was just an old college buddy that they had lost touch, and he came back to New York and needed a place to stay. And I busted up with my girlfriend, and she moved out and I needed help paying the rent. Then you get into the whole connotation of what we call brashing, which I'm sure everybody's heard and everybody despises, but that's a whole new avenue which would take a whole nother discussion, okay? They would then have to prove that they had a sort of familial relationship and that they shared financial co-independence. So that roommate, once the person moves out, does not have the automatic right to take over the apartment. If they're not a family member, they're gone unless they can prove brashing. They also have to have been there for at least 2 years continuously before the person moves out. There's all permutations within the law. Again, each individual situation is going to be different, but as a general rule, they have to prove their right to take over.
Okay,
Well, final
last question,
for
then we're going to wrap it
for
up.
code enforcement, and my friend Steve mentioned it at the beginning of the discussion, so I just want to clarify that particular point. And that is that lately there's been reports of HPD coming into post-1960 buildings, doing lead tests, and especially with the reduction in the threshold, the lead threshold, finding a positive result on door frames, which are positive because of the lead content of the metal itself and not the paint. Now, other agencies are accepting paint chip tests to prove that there's no lead paint there. It's lead-free buildings. And from my understanding is HPD hasn't been accepting that. So how can we deal with that? This is a lead-free building that's getting lead violations.
I'm actually not that comfortable commenting on this right now, just given some, there's pending litigation around what you're discussing. So I'm going to plead the fifth. All right. So,
But you could have it downgraded from a presumed lead. We'll talk off the record. Okay.
He's talking about the paint chips, us accepting paint chips.
Just going back to the attorney that spoke about the court backlog, just a quick question. I'm sure everybody has an issue with the backlog on signing warrants. The fact that the judges basically have issues with all these attorneys fighting for the tenants, I understand. But the question is, why does it have a backlog for this? And I have one more question. When you do a motion, a judge usually has 30 days to respond. We could wait a year to get response. What can we do to correct that?
Which borough generally are you building?
Warrants in the Bronx is about 6 to 8 months.
No, it's not. I know. My firm goes to every borough.
We use your firm.
Okay, it's not 6 to 8. That's good. It's not 6 to 8 months.
Actually, your firm we use in Brooklyn, not in the Bronx.
Now, if you use us in Brooklyn, I know in Brooklyn I'm getting warrants issued now in 2 months. Okay, 2 months. In Queens, I'm getting warrants issued in about the same. Manhattan, of course, gets treated better than anywhere else. We get warrants in 4 weeks. The Bronx, it's running about 3 months, 3.5, maybe 4. But that's what it's running. And by the way, think back. You've been in the game a long time, right? Even 10 years ago, the biggest complaint everybody always had was how long it took to get a warrant. Even 10 years ago, it took a month and a half, 2 months to get warrants. It did. In Brooklyn, Queens, Manhattan, it's no worse than it was 10 months. Bronx is the worst, but I think it's down to 4 months now. And a lot of that has to do with something that happened with a marshal that we all know passed away. And that created a backlog of warrants that had to be resubmitted. Okay? It was a tragedy what happened to Tommy Bia, but that backed things up a good 5 or 6 more weeks than the 3 to 4 months. So maybe for that period it got up to 5 to 6.
Okay, everyone, we're going to wrap this up now. The panelists are going to be sticking around for a couple minutes to answer more questions. Thank you, everyone, for coming.